All rise, veuillez vous lever. Please be seated, veuillez vous asseoir.
L'audience est reprise.
The hearing is resumed and defense has the floor for further closing statements.
Thank you very much, Mr. President. Continuing on the month of October, this was also the month where we had an incident that's been referred to as the Women's March. The march itself was not a charged incident, it was not a march against Ansar Dine, and it was not a march against the Islamic police. And as my colleague Maître Beaulieu-Lussier will elaborate, it was also not a march protesting rape. In their brief, the prosecution relied on 3 items of evidence, one a message porte, and the evidence of P603 and P582. None of these items substantiate their account. The message porte, that's MLI OTP 00120975, we have no information where the information in this document came from, whether it's first, second, or even fifth-hand hearsay. It's anonymous hearsay squared. The reliability of the source of the content of this document is further called into question by the fact that the source describes Mohammed Musa, who is the head of Hezbollah, or was. It describes him as the commissaire de police islamiste. And here, Your Honours, we come to the crux of the problem with this case. That Hassan is in the dock here today because prosecution witnesses and the prosecution itself confused the Islamic police with the Hezbollah. The Islamic police was in the BMS before going to the Gouvernaha, but you've heard evidence that after the Hezbollah moved in, the Islamic police sign remained for a period. And Your Honours, you have heard multiple prosecution witnesses concede that they wrongly assumed that the persons working at the BMS at this point were the Islamic police. The prosecution also confused and conflated the 2 functions of these distinct organs, an issue that will be addressed by Maître Youssef. Mr. Hassan did not work for Hezbollah. He had no authority over Hezbollah or Hezbollah members, and this is not a case of co-perpetration. A link between Mr. Hassan and the acts committed by independent organs and independent agents cannot be forged through an erroneous conflation of the 2. The message porte also says that the march took place between 10 o'clock and 12 o'clock on the 6th of October. P603 testified that she marched at around 11 a.m. As we've just discussed, the prosecution relies on evidence that on 6th of October, between 10 and 12 o'clock, Mr. Hassan was allegedly filmed sitting in the Gouvernaha. And in these videos, these films, we hear the calls he receives and we hear the calls he makes. None of them relate to the Women's March. In fact, we hear Khaled being asked, "Quoi de neuf?" What's new? To which Khaled responds, "Rien," nothing. Hassan is clearly not present at the Women's March, and he's clearly not involved in what is happening there. Let's circle back to P603, who testified about the march. When asked why she had never mentioned Hassan's name in interviews or reports that took place before Hassan's arrest, she conceded point blank to Your Honours. Hassan didn't do anything to us. He didn't even speak to us. He didn't do anything bad to us. Mr. President, Your Honours, the people of Timbuktu, even those who demonstrated don't believe that Hassan did anything bad, nor is there any basis for you to reach a contrary conclusion. Since P603 herself did not believe there was a foundation to convict Hassan, I'll move on to P582. The prosecution claimed in their brief, paragraph 285, that Mr. Hassan was present at the demonstration. Except that's not what P582 said. He actually told the prosecution that Hassan was not present when the march was taking place. And I refer you to the document 0062 4185 at 4190. P582 in the same interview told the prosecution that 4 women came to the police on 5th of October to obtain authorization to march. The police gave them this authorization. That's at 4180. P582 also explained that the next day, the women came to the Gouvernorat to assist them to find out what had happened, to be listened to. His account does not suggest in any way that the women were brought to the Gouvernorat against their will. P582 also told prosecution investigators that the Islamic police did not arrest or detain women. In sum, the Chamber has heard evidence that following this consensual meeting at the Gouvernorat, a meeting was convened on 9th of October with a crisis committee to discuss Hamid Musa. According to P150, during this meeting, the crisis committee did not give details, nor did they present the matter as an actual accusation that they wanted to resolve. That's transcript 112, page 75. And Maître Beaulieu-Lucier will elaborate that on this precise date, 9th of October, a member of the crisis committee publicly stated in the same Jeune Afrique article cited yesterday by the prosecutor, they said that they had no evidence of rape. Mr. Hassan did not work at the BMS at this point. He didn't have eyes and ears everywhere in Timbuktu, so there's no basis to conclude that Mr. Hassan knew of specific incidents of rape and sexual-based violence when other people with greater access to either Hamid Musa or the locals did not have this knowledge. There's also no foundation to conclude that after this meeting, Hassan knew that there was a virtually 100% chance that future acts of mistreatment would occur. To the contrary, you heard from P150 that following the 9th of October meeting, the Shura Council issued further instructions specifying that the Hezbollah could no longer issue tazirs directly. They were required instead to submit such cases to the tribunal. And you have seen in the evidence that after this point, Mohammed Musa's powers were in fact reined in. Specifically in November, you can see Hezbollah reports signed by Abu Abdallah al-Suki, Hamid Musa, and this was because he was required to refer matters to the tribunal rather than dealing with them directly. And as Maître Youssef will explain, that's why you see Hezbollah reports from that period and not before. D551 also testified that after this October meeting, he and his associates did not see Hamid Musa or his men making problems for women on the streets or at the markets. And that's transcript 200, page 83. Your Honours, the principle of indubio pro reo does not allow you to conclude, based on an assumption, that Mr. Hassan had actual awareness that exactions were committed by Hezbollah officers when individuals with greater proximity to the local community had no such knowledge. Finally, for October, the prosecution relies on a report concerning an individual called Mohammed Musa who was arrested at the airport checkpoint with suspicious items. My colleague Maître Youssef will explain that in this case, which is incident 20, again, the police were no more than a neutral letterbox, and this does not suffice to trigger responsibility. Turning to November, the prosecution has attempted to create mens rea by referring to the contents of another scripted interview stage directed by Abdallah Al-Tangeti. Now, we've addressed the fact that such scripted interviews lack probative value. And you can see that it's scripted because the words attributed to Hassan are almost identical to those of Abu Dar, who was filmed at the same time. Yesterday, the prosecution tried to inflate their empty mens rea casket by claiming that Al-Hassan laughed after referring to the amputation. Your Honours, this laugh doesn't exist. It's not in the video, it's not in the transcript. It's yet another example of conjuring something from nothing. His remark that thefts had reduced following the amputation is also purely observational. It does not demonstrate mens rea to knowingly contribute to crimes. It simply repeats or reflects common chatter on the street. And we have concrete examples of local chatter to this effect. And if you go to the video 00693735, you will hear a local shopkeeper thank God that the number of thefts has decreased since the amputation. He says, God has saved them from thieves. In a different interview, a local notable was filmed describing the reduction of thefts and rape due to Sharia, and he describes it as a positive development. That's transcript 133, page 39. Turning back to the contents of the November interview, the person states, thus far, there had been a total of 5 floggings, including 2 for alcohol. So it's reasonable to conclude from this interview that as of 7th November, if this is Mr. Al-Hassan, then he only had knowledge of the June flogging of the couple at Plus Sancore, the 2 unidentified individuals who were given 40 lashes, and the flogging of the Islamist Hussein Uld-Badi. The video disproves the prosecution case that Al-Hassan had any knowledge or involvement in other floggings occurring before this point. Turning to the end of November, the prosecution has tried to convict Mr. Al-Hassan in a manner that goes beyond the scope of the confirmed charges by relying on blurry photographs and his torture-tainted interviews. But neither body of evidence can be relied upon to prove the charge concerning the November flogging. And I'll start first with the photos. We don't know who took these photos. The person who gave them to the prosecution couldn't even recall how the photos were created or when they were created. He also acknowledged he wasn't present when the photos were taken. The prosecution itself did not call any witnesses who were present on this day. The basic threshold of authentication has not been met. And in terms of the photos themselves, there are serious irregularities concerning their digital properties. The person who gave them to the prosecution sent them in an email to a colleague along with a report, and the photo attached to this email was 00182590. The report attached to the email was created at 13:33 on 29th of November and later modified at 14:21. The email was sent at 16:08. The photo shows a woman in a black veil. It does not show Al-Hassan, and it does not show anyone being flogged. The prosecution has then relied on 3 other photos with a different woman. And the creation and modification dates of these photos is 29 November at 16:57. This means that they were created or obtained after the first photo and after the email was sent. And according to prosecution expert P75, there are indicia that the 3 later photos were accessed or modified by external software, Adobe Media Encoder or Adobe Photoshop for Windows. And the report is 0062 2399 at 2449. The information concerning this event was published. It was considered newsworthy, but the photos, however, were not. Now, if a media organisation declines to publish images from a newsworthy event, it's reasonable to infer that they had concerns regarding the reliability of such products. And this inference is corroborated by the following. We have a chat dated 3rd December between the person who obtained the photos and an Ansar Dine media office. And in this chat, the person's trying to obtain footage of a flogging concerning the stepbrother and the sister. And you've heard evidence, Your Honour, that this person would not have approached the media office. He would not have been searching for the event if he had already obtained it at this point. Transcript 48, page 63. And this person agreed that the most probable scenario was that he was not present at this punishment, or the punishment of the stepbrother and sister, on 29th of November, and that he had not obtained footage of it as of 3rd of December. Now, if he didn't have footage of it as of 3rd of December, he clearly didn't have it on 29th of November when the email was sent. This means that there is more than reasonable doubt that these modified photos from an unknown person on an unknown date are what the prosecution claims that they are. Mr. President, Your Honours, you can't pin a conviction concerning one event on photos that appear to concern something entirely different. Now, of course, the prosecutions also tried to use Mr. Al-Hassan's torture-tainted statements to shore up their case. And the way that Mr. Al-Hassan was led to answer their questions on this topic was dealt extensively by Dr. Morgan, and Maître Pradhan will elaborate. No credible justice institution can conclude that his answers were not tainted by his experience of prolonged and continuous forms of torture. Apart from the absence of reliable and credible proof that Mr. Al-Hassan participated in the charged flogging, there's no basis to conclude that he made a culpable contribution to the judgment that ordered this punishment. According to MLI OTP 00181035, the stepbrother and sister came to Timbuktu the Thursday before, following a complaint filed by the woman's father. The court data records indicate that the number attributed to Mr. Al-Hassan was pinging cell towers in Timbuktu-ville during this period, and the days before and after. You can also see from these records that there were separate antennae in Gundam, and that when he was in Gundam, the antenna would be pinged. The antenna in Gundam were not pinged during this period. This means that following a complaint filed by the father, the two individuals were brought to Timbuktu, most probably by persons from Gundam. The report concerning this case was also framed as a rape case. It records the father's account that his daughter had been drugged and forced to commit adultery. It also records her account that her mother and stepfather had tolerated her prolonged rape by her half-siblings. The report seeks accountability for allegations of rape, and since this was a complaint alleging a serious crime, the police were obliged to transmit it to the tribunal. The police were again acting as a letterbox. The judgment itself makes no reference to the police report. It records that the tribunal conducted its own investigation and obtained confessions directly, and this led to a result that was different from the outcome of the prior judgment in the Bokar case. The outcome was thus not virtually certain. Mr. President, Your Honours, it's reasonable to conclude that the Islamic police and Mr. Hassan took rape allegations seriously, ensuring they were documented. And this is what happened in the Bokar case, and this is what happened here. It is not, however, reasonable to conclude in this instance that Mr. Hassan's personal actions had a measurable impact on the decision that was made by the tribunal. Nor can you conclude that his personal actions intentionally increased the degree of harm that resulted. Moving to December. The events of this month disclose no basis to conclude that Mr. Hassan intentionally contributed to charged crimes before, during, or after the month. The tribunal issued no hooded punishments in December or January, and there are only 2 reports from this period, a theft report and another concerning cigarette trading. The theft report is addressed at paragraph 79 of the defence response. The cigarette trading report appears to relate to smuggling by traffickers. Now, this is contraband that was within the purview of security. It was a type of offence that could also not be dealt with by the police directly. The judgment concerning the case indicates that the tribunal examined the case itself, the tribunal ordered the destruction of tobacco, and the tribunal ordered the defendants to be released after 1 week in detention after pledging not to offend. All of these actions took place at the level of the tribunal, not the police. Once again, the police simply acted as a neutral letterbox. The penalty was also mild. And Your Honours, this is consistent with the fact that none of the judgments concerning the sale of cigarettes imposed flogging as a penalty. For example, in November, when a defendant was caught with 8 dozen cartons, he was only sentenced to pay a fine, and this was based on the profit he would have made. That's 0078 1626. This report, this judgment, should put to rest the ridiculous story concocted by P580 and his wife P642, that all of Al-Qaeda, all of Ansar Deen were pursuing him to the ends of earth, subjecting him to various outlandish punishments because his non-existent shop sold cigarettes. And when you read the transcripts of this outlandish, incoherent, this controverted account from P642, we suggest you heed the words of P608, a local from Timbuktu. And these are, the people from Timbuktu, sometimes they have a habit of inventing things. In terms of other actions attributed to Hassan this month, the prosecution has placed misplaced significance on an accreditation letter for a journalist that was allegedly signed on 11th of December. You heard evidence that even though this letter related to one subject, it allowed the journalist to report on anything in Timbuktu. You also heard evidence that Hassan's involvement was helpful, a positive contribution that facilitated the person's ability to report without fear of pressure. These are both on transcript 132, page 32. The conditions set out in the letter also came from the Media Commission, not the Islamic police and not Hassan. You also heard evidence that when the person concerned took the slip to be signed, Hassan himself could not sign it or approve it without first speaking to his supervisor. Once again, far from demonstrating blameworthy conduct, this letter demonstrates Hassan's ongoing efforts to assist and facilitate requests from the local population. It also does not support the prosecution's case that Hassan was acting as a de facto chief. Now, the Chamber doesn't need a crystal ball to see what would have happened if Hassan was not present. The Chamber can simply review the evidence concerning Gao, where journalists who had reported freely in Timbuktu were obstructed, and under risk of arrest. And I refer you to D246. Finally, for December, the prosecution relied on yet another scripted interview of video montage. As explained in our closing brief, the montage was filmed in the context of national reconciliation, and additional scenes not filmed originally were recorded separately and spliced into the footage. The video has no probative value and no demonstrated linkage to the case. Actions also speak louder than scripted words. Mr. Hassan played no role in the military activities in Kona and Diaboli. He didn't go to training exercises, and witnesses have confirmed that when Hassan was actually working, rather than acting in films, he didn't have a weapon. And I refer to transcript 133, page 90. And when the Chamber looks at Mr. Hassan's actions in December, they will also see him doing everything he can to help and protect the local population. You heard, Mr. President, Your Honours, D554's testimony, that as soon as Hassan was contacted by D554, Hassan roped in Adama, who was in security in this point, to help 554's wife leave the BMS, where she'd been taken by Hamid Musa and Hezbollah. D554 was not a Tuareg. He wasn't a relative of Hassan, he was just another local that Hassan helped by staying there. Things for him, things for his wife would have been worse if Hassan had not stayed and used his position to help. Coming now to January, the last month. According to the prosecution, this month represented the apex of Hassan's responsibility. We dispute the allegation, but even if you were to accept the highly unreliable foundation for the claim, let's look at what the police actually did in these last weeks. No police reports were issued or drafted in January. Indeed, the last dated police report is 4th of December. D551 also gave evidence that the police cancelled his appointment. So at the apex of Hassan's alleged responsibility in the police itself did nothing to contribute to the alleged common purpose of applying Sharia. Although there was an alleged flogging at the very beginning of January, there's no culpable link between this event and Hassan. Metro Yusuf will address you further concerning the fact that this incident was prompted by locals, pursued by Hezbollah, and then ordered by the tribunal. When the prosecution started this trial, they tried to create this missing link by claiming that Hassan was not only present when the woman was flogged, but he could be seen flogging her. And they made this claim to you even though they had evidence from P582 that the person in question was not Hassan, it was a Pul. And it was not a Tuareg, it was likely Ismail Diallo. This detail was omitted from the fanfare of their opening statements. When the video was shown at trial, all the defence had to do was enlarge the image, and it became abundantly clear that it looked nothing like Hassan. The prosecution's highly prejudicial error shows why the Chamber cannot rely on the prosecution's assumptions. You cannot follow them down the garden path to a conviction based on speculation because they haven't laid the groundwork. Even to this day, they continue to ignore the lack of certainty in their own case, asserting, for example, that individuals were brought to the flogging location by a police vehicle, even though first, P65 testified that the vehicle could be used by Hezbollah or the police, and second, the person who was flogged was held at the Hezbollah headquarters at the BMS, not by the police. This is not the International Court for Convictions. It's a court dedicated to justice. And it would be unjust to convict Mr. Hassan for incidents where they have not even demonstrated that he knew of the event, and there is no evidence of contribution on his part. Since we have no evidence of knowledge, no evidence of intent, and no evidence of contribution, there can be no conviction for these incidents. To finish their allegations against Hassan, the prosecution rely on diary notes concerning a meeting that took place in January as between members of the local population and Adam to discuss the rapidly deteriorating security situation. You've heard evidence that the local Arabs and Tuaregs were afraid. They knew that once Ansar Dine left, they would be targeted for reprisals, and they knew this because this is what happened to them in the 1960s, 1970s, 1980s, 1990s, and 2000s. And it's what actually did happen to them when Ansar Dine left. After conducting a peaceful march that failed to attract the support of local notables, members of the local Arab population threatened that they would take matters into their own hands to defend their property. I refer to transcript 135, pages 41 to 42. And this is the context in which the meeting occurred. You've heard different accounts of this meeting, but what P654 and P4 both agreed was that eventually a joint decision was taken by all those present that there should be no settling of scores or any actions that could threaten peaceful cohabitation. P4 testified that at the meeting he attended, Mr. Hassan repeated in French what others said in Arabic, as the meeting was attended by Arab traders. D551 further clarified that there were two meetings at this era. One, which concerned the protection of Arab shopkeepers, where Hassan was present, and the other, where the local population were warned not to insult the Islamists, and Mr. Hassan was not present at the second meeting. For this first meeting, D551 testified that Mr. Hassan was not in charge and did not speak on behalf of the group. He was just present. D551 also explained in his words that at that type of meeting, Hassan would not have much to say. There are only two conclusions that you can draw from this body of evidence. First, even at the very end, even at the apex of his alleged responsibility, Mr. Hassan is still acting as an interpreter or bystander. He doesn't have the authority to speak in his own name. He doesn't have a say in what transpires. Second, until the very end, Hassan was associated with efforts to achieve dialogue between the Islamists and the local population, to reduce tensions, to reduce harm. I have now gone through each month of the Taj time period and the different actions attributed to Hassan, and whether the Chamber views these events holistically or on an individual basis, the conclusion is the same. The link of culpability is missing. In 2019, I appeared before the pre-trial chamber and asked them to throw this little sardine back into the sea, and there's been no developments, no evidence that has been heard since then that changes this request or changes this conclusion. Mr. President, Your Honours, the people who stayed in Timbuktu, who lived it, you have heard today that they don't consider Mr. Hassan to be responsible for the acts described to you by the prosecution. The highest authorities of Timbuktu have confirmed what I said to you today, that by staying, Hassan helped them, and his conduct does not warrant punishment. The local community of Timbuktu, Songhai, Arabs, Tamashek and Tuareg, they want him home. And we ask you to let this happen and to acquit Mr. Hassan in full. I'll now turn over to Maître Pardon.
Très bien, merci beaucoup, Maître Taylor.
Presiding Judge, thank you very much, Ms. Taylor. The Chamber is now ready to hear from your colleague.
Merci, Monsieur le Président, Madame les juges.
Thank you, Your Honour.
As it is the first time I'm addressing the Chamber during this session, I would like to greet the Chamber and everyone here and our guests in the gallery as well. As Ms. Taylor outlined, I will make submissions addressing the prosecution's failure to prove chapeau requirements regarding situations of armed conflict and crimes against humanity, as well as discussing the fatally flawed evidentiary foundations in this case. I would like to begin with our submissions regarding the existence of and nexus to an armed conflict. We submit to you that accepting the prosecution's arguments here would not only contravene the evidence before the court and the previous case law of this court, but it would seriously weaken the ability to identify and litigate armed conflicts around the world according to the prevailing legal standards. Yesterday, the prosecution told a story that some may find compelling on the surface, but which contained no reference to the law and precious little reference to facts in support of the law. The reason is because neither facts nor law support the prosecution of this man, these crimes, in this court. As my colleague Ms. Taylor did, I'd like to start with the law and the legal standards and then focus on the facts and evidence before this chamber. The prosecution failed to prove beyond a reasonable doubt the threshold legal standard for jurisdiction, whether an armed conflict existed at all. There's a long-standing distinction in international humanitarian law between an armed conflict and less serious forms of internal violence that may be harmful but cannot rise to the level of armed conflict in order to prove the existence of an armed conflict. As the Chamber is aware, the prosecution must prove sufficient organization of the groups and intensity of violence. I'd like to start with the prosecution's attempt to show organization of the groups. At paragraph 704 of the Taganda trial judgment, the Chamber provides a non-exhaustive list of roughly 18 factors and indicators to be analyzed in order to find sufficient organization of an armed group. These include details related to command structure, unified military strategy, implementation of Common Article 3, the ability to speak with one voice. Under Taganda and its predecessors, the prosecution had the burden to prove, beyond a reasonable doubt, that some combination of these factors existed with respect to the groups in Mali. But what the prosecution asks this chamber to find, for the first time in an international court or tribunal, is that a single factor can be individually determinative. In the prosecution's words, the ability to conduct complex military operations, including to take and hold territory. Nowhere in the prosecution's arguments, either oral or written, is reference to the rest of the factors with respect of any of the individual groups in Mali whose acts the prosecution later seeks to aggregate, and I'll speak about that in a moment. In Taganda, the trial chamber went through each of these categories methodically and in turn over 6 paragraphs, paragraphs 704 to 709. In the present case, we submit that this chamber would be unable to provide the same analysis in a trial judgment that the Taganda chamber provided, not only because of a lack of argument by the prosecution, but because of the lack of evidence on the necessary criteria. The prosecution yesterday, and in their response to the defense final brief, specifically refer, in passing, to Al-Qaeda and Ansar Deen as possessing sufficient organization for an armed conflict. And so with respect to those two groups, we submit the following. With regards to AQIM, from January 2012 to January 2013, according to P99, AQIM was composed of disparate brigades without unified leadership, with many of those individual parts remaining uninvolved in the conflict. According to P4, AQIM had no unified strategy, nor was there any clear command structure. And these were prosecution witnesses. Critically, the evidence has shown that Timbuktu was administered by AQIM not after complex military operations, but rather after abandonment by the Fama. And prior to their entry into Timbuktu, there is no probative evidence that AQIM exercised territorial control over any specific areas in northern Mali. So the single organizational factor set forth by the prosecution to establish an armed conflict did not exist prior to April 2012. The prosecution here attempts to use the holding of territory as a single factor in isolation to retrospectively claim an armed conflict for the purpose of jurisdiction here. With regards to Ansar Dine, there's likewise no evidence that shows that Ansar Dine promulgated military regulations during this period or had any system to discipline its members. According to one prosecution witness, Ansar Dine lacked sufficient strength to face a conventional army, which the trial chamber in Boskoski found significant to its lengthy analysis of whether, I apologize, Your Honors, should I pause? Okay. Which I alluded to the fact that
Non, non, maître, poursuivez s'il vous plaît.
Please continue on.
I alluded to the fact that the trial chamber in Boskoski found a group's strength to face a conventional army significant to its analysis of whether the Albanian National Liberation Army possessed the requisite organization in that case. The prosecution has the burden of proof on this point, and even in their response, they fail to carry it. Moving to intensity, the second factor. The prosecution tried to show the intensity of a purported armed conflict by adding together everything that all the groups present in Mali were allegedly responsible for to try and reach that threshold. Now, groups can, of course, act in concert, but there is a legal standard for when you can combine the acts of different groups, which the prosecution has entirely disregarded, because it means not only that they have to prove the organization of each individual group, but that they have to prove intra-group organization of some sort. The ICRC states that proving or coordination and cooperation among groups in a non-international armed conflict requires the showing of a number of factors, including, for example, establishment of a joint centralized command, allocation of areas of responsibilities, sharing of operational tasks, the existence of common standard operating procedures or rules of engagement, and the existence of an umbrella platform dealing with political issues and communication in the names of the members of the coalition. The evidence in this case shows that to attempt an argument that these groups were acting in concert would contravene the facts that we have about the distinct methodologies and philosophies of the groups. Prosecution witnesses testified regarding, for example, the opposition of AQIM and Ansar Dine to the rapes and pillaging conducted by the MNLA. My learned colleague yesterday highlighted that Ansar Dine and Al-Qaeda, quote, chased out the MNLA, end quote, from Timbuktu. How would they have done so if the groups were working in concert? The evidence overwhelmingly illustrates how fractured and even at odds the various groups were. And their acts cannot possibly be grouped together to qualify them as a combatant side fulfilling the intensity standard of an armed conflict. The prosecution cannot show an armed conflict, and they certainly cannot show that any purported armed conflict continued after the Fama left Timbuktu. You heard the prosecution refer yesterday to the internal military coup d'etat in Bamako and tried to tie that coup to the proposition that Ansar Dine and AQIM took Timbuktu. The reality is quite different. As mentioned, the Fama collapsed due to defections following the coup, as detailed by the international community, including, for example, the International Crisis Group, and confirmed by prosecution witnesses, including P-1086. Now, if, Your Honors, despite evidence to the contrary, this chamber finds that an armed conflict may have existed among scattered groups and over sporadic periods of time, there is simply no nexus shown between the armed conflict itself, as purported, and the acts with which Mr. Al-Hassan is charged, which are based on the application of civilian regulations. The prosecution has stated in its response to the defense final brief that, quote, the ICRC has long argued that situations where a non-state armed group establishes control over territory and then seeks to impose its own rules upon the civilian population are precisely those in which international humanitarian law should apply, end quote. In reality, the ICRC has long argued no such thing. In fact, the single article by a legal scholar that the prosecution provides for this statement at footnote 78 of their response. In that article, several authorities are cited for the opposite proposition, that in fact, with regard to everyday life, including interactions among civilians, human rights law is the more appropriate and protective legal framework that should apply. The author himself, Dr. Rodenhauser, notes that, quote, the interpretation of the nexus requirement as presented in this article, his own article, has been criticized as a one-sided approach to civil war that does not sit well with the fundamental principles of IHL, by which all parties to a conflict are regarded as equal. That principle of equality is, in fact, one that has not only been long argued by the ICRC, but long resolved, and applies to the civilian administration of Timbuktu during the charged period. In armed conflict, the law enforcement paradigm exclusively governs the exercise of administrative, disciplinary, and judicial authority over occupied territory and the civilian population and persons deprived of their liberty. In Timbuktu, after April 2012, the evidence shows that there was a complete vacuum of governance. When Fama left, the civilians were left without police or judges or infrastructure to regulate anything. And the population was left vulnerable. This was the point at which AQIM and Ansar Dine stepped in to form an administration, not by their own rules, but in fact implementing widely accepted elements of the Maliki school of Islamic law, which is prevalent in North and West Africa and countries including Kuwait, Bahrain, Qatar, Dubai, and northeastern parts of Saudi Arabia. As my colleagues, Mr. Youssef and Dr. Gary, will also discuss, the Maliki approach was established as policy prior to Mr. Al-Hassan joining the Islamic police, and as evident from its prevalence, is consistent with international law and cannot be read to be inherently inconsistent with international law. The neutral status of police and law enforcement, unconnected to any existing armed conflict, was given special consideration during the drafting of the Geneva Conventions. Regardless of varied opinions of the establishment of Sharia and the administration of Timbuktu by AQIM, it seems that those facts alone underpin the prosecution's insistence that an armed conflict existed from April to December 2012 for the purpose of prosecuting Mr. Al-Hassan in this court. Even more troubling, while policing civilian activity, again, is generally unrelated to armed conflict, it seems that the mere addition of the word Islamic to the title of the police makes Mr. Al-Hassan some sort of combatant, even though the Islamic police, as you've heard from my colleague Ms. Taylor, played the same role within Timbuktu as virtually any other police force in the world. If individual excesses occurred within the governments of Timbuktu, they occurred in the same way that incidences of murder, rape, and assault are found to be committed by members of, for example, the New York City Police Department, and handled under regular criminal law, even though the United States has been in a purported armed conflict since 2001. And of course, the preponderance of the crimes in Timbuktu outlined by the prosecution yesterday were not even committed by the Islamic police, but by other governing agencies. Distortions of humanitarian law, like those proposed by the prosecution, simply cannot be the basis for war crimes charges in an international court, and could have serious consequences for the universality of international humanitarian law. We submit that a proper application of the law in existence at the time of the charged acts results in a conclusion that no nexus existed between the police functions in Timbuktu and any purported armed conflict. I'd like to move to a discussion of the chapeau requirements of crimes against humanity. A fact-based inquiry shows just how difficult and complex the situation was on the ground in 2012. We do not envy our learned colleagues in this respect, but they have the burden to prove under Article 7 of the Rome Statute that AQIM or Ansar Dine actively promoted or encouraged an attack against the civilian population as an organizational policy. As you've heard, Islamic tribunal judgments were instigated through complaints submitted by civilians and concerned a range of issues, much of it essentially magistrate work. Such civilian-triggered functions cannot logically constitute an attack or a crime against a civilian population at large. According to witnesses D605 and P654, the judgments themselves were issued by tribunal members who were not all affiliated with either AQIM or Ansar Dine, and who made independent judgments that sometimes conflicted with Ansar Dine or AQIM policies. Prosecution witnesses P152 and P150 described how Ansar Dine and AQIM leaders, such as Drukdel, actually disapproved of severe punishments during the charged period, and that compensation was paid to individuals. Now, does this mean that no crimes took place during this period? Certainly not. And we have heard from the victims of some of those crimes committed by individuals who were not Mr. Al-Hassan. And while terrible in many respects, they do not fall within what this court categorizes as atrocity crimes. Regarding those individual crimes, I heard reference by the prosecution yesterday to Mahmoud Musa. But what was left out was that we know that Mahmoud Musa was a member of the MNLA for the first part of 2012, when, according to prosecution witnesses and the United Nations, the MNLA was involved in mass rape and pillaging. Mahmoud Musa later led the Hezbollah, after which he was individually responsible for crimes against women and other civilians, and encouraged others to commit such crimes. But we also know from witnesses, including D605, that the organization opposed Mahmoud Musa's illegal acts, and that the situation improved once he was replaced, as Ms. Taylor just discussed. We also know from D202 and D605 that Ansar Dine investigated rape complaints and punished perpetrators. And throughout, the 40 men of the Islamic police were distinct from the Hezbollah. And it is that critical distinction that the prosecution is trying to obfuscate again and again in characterizing Mr. Al-Hassan and his role here. We submit that nothing in the evidence before this chamber about the punishments suggests that they were widespread or systematic as required by Article 7.1. As tragic as many of us find such uses of force, the single amputation and handful of punishments over 9 months cannot constitute an attack, much less a widespread or systematic one, against a civilian population in Timbuktu of 780,000 people. The prosecution yesterday tried to extrapolate from the crimes that actually took place to a generalized atmosphere of abuse in Timbuktu. To the contrary, even the United Nations, in a report issued in November 2012, in the record at MLI OTP 0001 2113 at 2117. The United Nations there characterized the number of abuses in November 2012 as not high. The seriousness of the individual events is still not the same as the weight that must be given by this chamber to the legal standard in assessing a prosecutable crime against humanity. There are two clear conclusions here. The first is that Mr. Al-Hassan himself has tenuous, if any, connection to the crimes that took place in Timbuktu in 2012, and no oversight responsibility for them. He was one man of 40 in a subordinate agency. The second conclusion is that there was no policy to commit crimes constituting a widespread or systematic attack on civilians that was promoted by any particular organization, including Ansardine or AQIM. I'd like to turn now to the contamination of evidence in this case. It is our submission that there are 4 factors affecting the evidence here. The first is race and ethnicity. The second is pervasive public bias promulgated by media and NGOs. The third is the sheer passage of time. And the fourth is torture and cruel, inhuman, and degrading treatment affecting the probative value of evidence. I will address each of these in turn. First, we submit that race and ethnicity is a huge factor in this case. Mr. Al-Hassan is a Tuareg, a member of the minority in Mali, and P160, for example, admitted that Tuaregs were, quote, automatically associated, end quote, with Ansardine or the MNLA, which is problematic because, in fact, as I mentioned, the MNLA was the group largely responsible for rapes, not Ansardine. This morning, my learned colleague from the legal representation for victims said that victims, quote, use words such as jihadist or Tuareg, and he called such words, quote, keywords, seemingly interchangeably. I cannot think of a better illustration of this pervasive bias. Arabs, collectively, were sometimes basely associated with Mujal or AQIM. P160 also conceded that individuals in Timbuktu found it difficult to distinguish between responsibility of individuals, they blamed groups as a whole, and if they knew the identity of a perpetrator, they would blame the group associated with that ethnicity. The second factor that I'd like to address is bias. And NGOs and the media, sadly, played a key role in shaping false narratives throughout 2012 and after, regardless of intention. We heard evidence concerning the way in which, for example, the Wildaf Project, one of several NGOs on the ground in Mali, how that project unfolded with highly questionable documentation processes. Another NGO that shaped the bias on the ground was the FIDH. P642, for example, testified that the FIDH led witnesses to believe that they would receive aid as a result of their claims. And the evidence shows that several prosecutions and that's at transcript 152, page 80. We heard this morning an extraordinary statement, again, from my colleague in the legal representation of victims, who stated, the locals, the identity of their occupiers was at one point unclear. They mixed ideas on it. Now, those things are totally clear to them at the end of this trial. That's at page 18 of the transcript from this morning. This statement actually forms a bridge between the factor of public bias and the third factor, passage of time. Witnesses were testifying 9 years after the events, which already affects memory to a certain extent. We know that prosecutors told P522 and P524 in 2016 that they did not want to take certain witness statements at that point, even though they would likely be more accurate closer in time to the events. And the reason the prosecution gave for not taking statements at that point was simply to avoid triggering disclosure obligations. And that record is MLI OTP 0037 1249 R1. Now, it does not take a memory expert to find clear tension between the prosecution's priority and the quality of the evidence. In the same document, there's an uncomfortable section describing how the prosecution team, quote, is reviewing the victim's procès-verbaux and finding ways to improve the quality of these procès-verbaux in terms of getting the type of information required to prove these specific crimes, end quote. So in 2016, 3 years after the events charged in this case, and 1 year before Mr. Al-Hassan was captured and interrogated, the prosecution just didn't have sufficient evidence to elucidate crimes committed that are prosecutable by this court. And now, in 2023, we submit that the process as now completed by the prosecution has been so flawed through witness influencing and the factors that I just mentioned that the probative value of the evidence has been stripped. Turning finally to the last factor, contaminating evidence in this case, the torture and coercion affecting the probative value of the evidence under Article 69(4). In the words of one prosecution investigator, Mr. Al-Hassan's conditions of confinement during ICC interviews were, quote, the same as Guantanamo Bay, end quote. That is a phrase that causes recoil, because everyone knows what Guantanamo Bay represents: torture and arbitrary detention, as found over and over again by the United Nations. That statement, caught on recording from the prosecution, was an admission. It was an admission that first, Mr. Al-Hassan was a victim of horrific abuse and torture. And second, that the ICC prosecution team was very aware of it. They did not torture Mr. Al-Hassan personally, but they still seek to benefit from the fruits of his torture in a court created in part to prosecute the crime of torture. And this is disallowed under Article 69(4). The court heard evidence confirmed by prosecution and defense witnesses that upon arrest, Mr. Al-Hassan was kept in a 1 meter by ½ meter room. He was waterboarded. He was threatened with electrocution and mock executions, interrogated while hooded, and subjected to additional techniques in combination. When transferred from French to DGSE custody, he was beaten until he lost consciousness, threatened with death and death to his family if he didn't answer questions to his torturer's satisfaction. He was subjected to falaka, beatings on the soles of his feet, stress positions, including being suspended from a metal rod for hours, and forced to relieve himself in his own clothes. For 9 months, as the prosecution interviewed Mr. Al-Hassan in the horrific conditions described by Ms. Taylor, he was being held arbitrarily, abused regularly, and other than the prosecution interviews, was incommunicado from anyone, including his family and from any regular judicial process. The chamber heard expert testimony, which confirmed that Mr. Al-Hassan's torture and coercion affected the probative value of his statements when he was interviewed by ICC prosecutors to obtain evidence they have relied upon during this trial. The chamber heard from Doctors Catherine Porterfield and Juliet Cohen, who are world-renowned in recognition of the sequelae of torture, and from Dr. Charles Morgan, who's an expert on memory and the creation of false memories. Now, a quick note regarding these three experts. The prosecution has, in their briefs several times, complained baselessly about what they call flawed methodologies and a lack of neutrality regarding the defense experts. Now, in fact, the prosecution had the opportunity to cross-examine each of these experts on their methodologies and objectivity, and the expert opinions all held firm through such scrutiny. Each expert testified that they had all the information necessary to arrive at their conclusions based on their considerable professional experience. They explained how and why they disregarded certain evidence as unscientific. And, as specifically discussed by these experts, particularly by Dr. Porterfield, who conducted extensive in-person evaluations of Mr. Al-Hassan, Mr. Al-Hassan was specifically tested for malingering, exaggeration, or fabrication, with negative results. The testimony and reports of Doctors Porterfield, Cohen, and Morgan should be afforded the weight and credibility of experts with extensive experience in highly technical fields. And the conclusions that they reached all cast serious doubt on the probative value of Mr. Al-Hassan's evidence, as well as the prejudice that his evidence may cause to a fair trial. Dr. Porterfield testified that even in her evaluation years after the abuse, Mr. Al-Hassan showed signs of cognitive impairment that would have affected his interviews in 2012 and 2013. In response to the prosecution's argument that they informed Mr. Al-Hassan of his rights, including the right to remain silent, during those interviews before obtaining his statements, Dr. Porterfield testified the affirmation of detainee rights by the prosecution was, quote, overpowered, end quote, by the reality of the abusive and torturous conditions of confinement at the DGSE. These conditions created the environment by which Mr. Al-Hassan's evidence was impermissibly compromised. Dr. Morgan, independently upon review of Mr. Al-Hassan's interview transcripts, walked the chamber through a step-by-step analysis of false memories created by the prosecution's interview methodology. Now, false memories are not rare. They are well-documented phenomena in psychology wherein over 85% of people subjected to uncontrollable stress, as all the experts agreed Mr. Al-Hassan was, agree to narratives that are untrue. One of the incidences that the prosecution leans on in this trial is Mr. Al-Hassan's so-called admission to prosecutors that he personally participated in one particular man's flogging. In painstaking detail, following review of Mr. Al-Hassan's interview transcripts, Dr. Morgan described how that specific memory came to be created. He said, quote, I note this section of Mr. Al-Hassan's interviews because the process of OTP's questioning, quote, is like a recipe of what we would do in research to create a false memory, end quote. The detailed analysis is laid out in paragraphs 297 to 303 of the defense final brief. But in Dr. Morgan's words, quote, I highlight it because as you follow the course of the interview, regarding this particular flogging. The progression is from Mr. Al-Hassan saying, "I don't remember," getting him to generally recognize and acknowledge that he recognizes a place. He perhaps recognizes an individual, and then showing him photos. And we find that photos or videos are very effective ways of influencing someone's memory. And adding in the narrative of how many people were being whipped and flogged, and including the phrase, "You were there." This is a direct example of how we believe we get false confessions from people in an interview process, whether or not it was intended on the part of the questioners. And that's T179, pages 47 to 51. Dr. Morgan found overall that the conditions of the prosecution interviews with both Mr. Al-Hassan and P626 were so pernicious that, quote, "It is within a reasonable degree of medical and scientific certainty that the information each of these witnesses provided during their sessions with the ICC investigation team is subject to substantial error." We submit that at an absolute minimum, there is reasonable doubt as to the probative value of Mr. Al-Hassan's answers to the prosecution's questions during this period of his abuse. His answers cannot be relied upon by this chamber under Article 69(4). The witness testimony heard by this chamber may change the course of a man's life. And so we submit that the veracity of it, regardless of intention, is what this chamber must examine. And upon examination of these four factors, it is clear that the prosecution's witnesses again and again conveyed inconsistencies and sometimes false and verifiably incorrect information that eviscerates the prosecution's case against Mr. Al-Hassan. Now, the prosecution makes an interesting statement in their response to the defense final brief, and this is at paragraph 124 of their response. They state, quote, "Corroboration does not mean that two pieces of evidence must be identical in every particular, but it rather implies a fact-sensitive comparison of salient points based on the compatibility of two pieces of evidence with regard to the same or linked facts." Now, the long-established exception to that statement is that the testimonies to be compared must be prima facie credible. That's why the ICTR, in the Gatete appeals judgment, which is cited by the prosecution in support for that particular statement, made the distinction at paragraph 125 of that judgment that two testimonies corroborate each other when, quote, "One prima facie credible testimony is compatible with another prima facie credible testimony regarding the same fact or series of linked facts." We submit that unreliable memories created in witnesses shown to have experienced uncontrollable stress, as Dr. Morgan highlighted, in circumstances presenting a real risk that torture occurred, which is the legal standard, are not prima facie credible and therefore cannot corroborate each other. It is our submissions, as you've heard, Your Honors, that the evidence is clear that there was no armed conflict under IHL at the time of the charged offense. And in the alternative, any conflict had ended and had no nexus to the charged offense. The chapeau requirements of crimes against humanity instituted by this court were not met by the prosecution. And the prosecution yesterday placed emphasis on courts needing to have the safeguards generally recognized as being indispensable for a fair trial. I am sorry to say, those safeguards have not all been present in this prosecution. Among the safeguards that my learned colleague mentioned as indispensable were the following. First, people having access to court or judge to contest pretrial detention. Mr. Al-Hassan had no access to court or judge to contest his detention at the time that the OTP interviewed him. Second, respect of the right not to incriminate oneself. In pursuing interviews that under conditions that they themselves acknowledged to be coercive, the OTP violated this right of Mr. Al-Hassan when he stated repeatedly that he was not able to remember facts or was unwell and suffering from his treatment. They continued to violate that right. And third, among the safeguards, is prohibition of the use of torture, which includes the prohibition on torture-derived evidence that cannot be reliable or probative. The prosecution knew of Mr. Al-Hassan's torture and conditions of confinement at the DGSC. They never once ordered an investigation. They simply pressed on with their questioning. Mr. Al-Hassan's right against the use and exploitation of his torture may yet be safeguarded by this chamber through recognition that the taint that has attached to the evidence in this case is too heavy to be considered justifiable in any case, and it strips the evidence of its probative value. The International Criminal Court cannot ignore or benefit from injustice in the course of pursuing justice. Neither the intention nor control of the prosecution regarding any of the factors I've just outlined can excuse the procedural and substantive shortcomings in this case in a court of this consequence. And at this time, I'd like to hand the podium to my colleague, Maître Melissa Beaulieu-Lucier. I note that I lost time.
Oui, Maître Pradam, je ne pense pas que vous pouvez donner la parole
Ms.
à
Pradam,
votre collègue.
sorry, I don't think that you can give the floor to your colleague because it's almost time.
Il nous reste
We
2 minutes.
do have 2 more minutes to go,
C'est pas la peine.
and in 2 minutes, I don't think we
Maître Pradam, je voudrais
can
vous
do
remercier
much.
très sincèrement
Ms.
pour
Pradam, I want to very sincerely thank you for your very excellent presentation.
et je renouvelle évidemment mes remerciements
I also extend my thanks to Ms. Taylor for her excellent statement as well. We have come to the end of our day for today, and
de parole.
I don't see anybody asking for the floor. Well, I see the prosecutor is on his feet. Mr. Duterte. Thank you, Mr. President. Just for the record, I want to point out that Marie-Jeanne Sadarki, Moussarafi, and Sandra Schott has joined us in the second session of this morning. May this appear on the record, Mr. President, as required. Thank you.
Tout à fait, Monsieur le Procureur. Merci beaucoup.
Very well, Mr. Prosecutor. Thank you very much. It is very important for this to appear on the record. And I take advantage of this time to cross-check with the other teams whether there have been any changes.
No, Mr. President, thank you.
Merci beaucoup, Maître Taylor.
Thank you very much, Ms. Taylor. Mr. Sita? There have not been any changes on the team of the legal representatives, but allow me, Mr. President, to ask about the planning for tomorrow. How much time does Defend intend to use? I ask simply so that we can organize our diaries accordingly. Presiding Judge, thank you very much, Mr. Sita. You're right. Let me turn to the registrar. Court officer, please. The defense is entitled to 4 hours ordinarily. Is that correct? How much more time do we have?
Voilà, Madame la greffière.
The registrar, the court officer, is quite vigilant, and so, Ms. Taylor, you have 1 hour and 6 minutes remaining. Do you agree?
Thank you, Mr. President.
Merci beaucoup. Il n'y a pas d'objection du côté.
I see no objection from Ms. Taylor. Thank you very much.
Avant de mettre fin à
Now, before we call it a day for today, as usual, I would like to very sincerely thank the parties and participants for their cooperation and the cordiality obtaining in the courtroom. Thank you very much. I also want to thank our interpreters and our stenotypists, court reporters, our security officers, without forgetting the public gallery. Thank you. And I wish everybody an excellent evening. See you tomorrow morning at 9:30. I'll adjourn the sitting for today.
All rise, vers le vert.